Hello, hello, it's Patty Jo. It's been a couple of days. Okay, first of all, I want to say that I do have one recording. Everybody knows that I don't do a lot of fancy stuff. I'm not super good at. So I just I'm myself and I record them and then I upload them as quickly as I can. I did record one the other day. Boring. Boring. So boring that it's still sitting there. I'll probably upload it with one that's not quite so boring, but we're into the phase where this isn't going to be good until we get to the closing arguments, and then I'm kind of 50-50 on if I'm going to do the victim responses in line with everything else, or if I'm going to snowflake out and do something kind of in the middle, just to kind of relax, because I've had a couple of snowflake moments, and I'm pretty sure I'll tangent off into that, because we all know I do. But I'm kind of 50-50 on putting up that really boring one. There's like 30 seconds of it that might be worth a listen, and the rest of it is just trash. Shout out to Donna Burrows. Thank you so much for supporting me. You don't have to, and I really like it. I'm going to invest some in, people who are in need, and maybe some in a microphone. A microphone, that'd be good. So you can hear me and I don't sound so stupid. Now, I have the light on right now, but I have been working the past 2 nights and I look like trash. So we might be darkening this a little bit. Just mood lighting. We'll see. When I'm not looking at myself, it's such a beautiful day outside. I don't really feel like going out. So let's see where we are. And if this is another like boring part, or if we're going to get to it. But I think really the next ones that are going up are going to be the the closings. All right, so here we go.
Yeah, maybe.
All right, thank you. Be seated. As soon as the doors close, I just need to put a couple things on the record. As I read, the doors closed, right? There we go. As I read through the bail jumping, it dawned on me that the battery should not be referenced because the battery was not on Main Street. And so I took it out. Because the way that the charge and the information reads, and we had that discussion preliminarily, which is why later on it doesn't reference the.
I'm sorry, lawyers and judges and all the legal people. So far, this has been like a circus, so really kind of interesting. But a lot of this is like watching paint dry. I'm gonna
Instruction for battery.
Ugh.
So I cleaned that up by rereading it and taking that out. So I wanted to make a record of that. Obviously, I will need to have a new set made that has that correction, and I apologize for not catching that previously, but obviously I caught that as I read it. There was one other heading that said preliminary on, I think it was instruction 70. I need to cross that out, and I think I found the word a or depending on how you say it, missing from one thing. I'm going to add that in, and I'll have that for the parties. And then I did note that at approximately 12:19, it may have been a little bit earlier than that, but I noticed Mr. Brooks was waving his hands. At one point I did indicate I would address that at a later point in time. I am aware of a number of filings. I addressed 2 of them previously, but there are 2 additional. I am going to have copies made of all of these filings for the state so that they have an opportunity to review them. From my perspective, just briefly, he's making some objections to what I am doing, but at no time in those did he ask to be brought back to the courtroom, and certainly within those, he did not pledge to follow the basic tenets of courtesy and decorum. Given where I was at in the proceedings with the reading of the preliminary instructions, and given the court's prior finding that he had forfeited his right to be present, I thought it important to get through the reading of the instructions up until the point of the closing argument instruction, which I reserved because I'll review that with the jury when they come back, prior to the parties being given their opportunity to give closing arguments. I will also be advising Mr. Brooks that given that I'm moving on to a second part of this, that being the closing arguments, he will be invited back into the courtroom here for those closing arguments, of course, subject to his conduct. I expect that he will follow the rules of courtesy and decorum, and also not raise legal issues in front of the jury when they are here. With that, we will take our lunch recess. It's 12:47. We'll take an hour and 15 minutes. Thank you, everyone. So yeah, I'm gonna make copies of all of these.
Okay, so I think that was a continuation of she was reading jury instructions and always making corrections, and there's a lot of detail-oriented stuff that goes into this. I'm impressed as well as bored, I gotta say. So let's see what else is going. Okay, here we go. I'm kind of fascinated with these little silent parts when they slip in. Everybody gets up at him.
That's from yesterday too. You gotta scan that in too. Okay. And then, do you have the sheets for me? From the yellows?
Mm-hmm.
The yellow. His yellow sheets.
Yes.
Isn't there a fourth one?
There's more.
No, there's one on your. I bet on your.
Might be still in
Yeah.
there. Hey.
Thank you.
Mm-hmm.
All right, it's 2:00. I'll call the case. State of Wisconsin versus Darrell Brooks. Case number 21 CF 1848. May I have the appearances, please.
Good afternoon,
the judge, Sue Author, Leslie Daisy, and Zach Wichow appearing for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Duro. This is a social security, CESTQ, trust action which you are a real party and interest to as sui juris and propria persona. This is a military admiralty tribunal and maritime law under Title 4 of the United States Code Section 1, which you can see, which states placing of fringe on the national flag is within discretion of president acting as Commander-in-Chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Daryl Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, what has yet to be proven on the record.
You have yet to agree with me on the records. Oh my God.
May I receive those original copies time-stamped?
No, shut up.
All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that, and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We've missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's...
I accept the value in return for value of this document, and Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
You know what? I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments.
I am so sorry to interrupt her. I'm going to pause this real quick. I've been eating today. I'm going to get a snack. Sorry. Okay, so don't really want to gross you out, so I just got some frozen fries. Okay, moving on.
The scope of the arguments, are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right. Then with that, I will have the jury. Oh, go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's going to put it like right here, and then you want me standing at this table during
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long as
I was going to put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection. What is that? What is supposed to be
Objection.
put up?
They're previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but I'm
terms
saying
of-
I don't understand what's being shown. Should not have the right to ask, to object and ask what it is that's actually going to be shown.
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing argument.
So can I put up exhibits?
Yeah.
Um,
Like what? You didn't have any.
Mr. Brooks, I don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up
Well, I
exhibits?
guess it depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is once the state
that was gross.
goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular, what are you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously.
I'm busy.
It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments, so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or...
He really needed a lawyer. Oh my goodness. I mean, I am never going to complain about hiring anybody with this level of expertise ever again in my entire life. Ever again. I have no complaint. He just wants to... You know, the saddest part of this is all Daryl Brooks ever wanted his whole life is to be included. And he can't even include his own name to himself. So the fact that he became a monster, I don't think he started out that way. And, you know, there's little snippets of just anybody who wants to be included. And they're just awkward and weird. Like, that's me. That's me.
Or like that
Identifying
would
with a
not be
monster.
something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific.
I was
my other
specific.
filings. that was
That's not
filed.
specific enough, sir. What are you
My
referring
court
to?
docket
Which
sheet.
filing?
Let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done?
Are you done?
Are you done?
Are you
Sir,
done?
that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you
Finna.
done?
Which?
He was finna say something.
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it
Because
to
you
be
don't
something
even know
that
how
it's
to
not?
be.
I didn't know if you was gonna say something.
And this is where he falls off the wagon, because you don't know how to be a civilized human being. You are so primal in your behavior. There's mine. You wicked, evil monstrosity. You are so primal in your behavior that you've lost me in any kind of, or anybody. Nobody can feel anything for you. That's why you went to court that other time for running over Erica Patterson's leg 3 weeks before this mess and had a big old black eye. Even the ilk of society doesn't like you.
Else.
Oh.
I've asked a question, sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All my
With
filings,
Statement of
my notice of
particulars.
appearance, my statement of particulars, my bond, the court docket sheet,
Or docket sheet.
all of those filings.
The request to display those to the jury is denied.
Thank you.
It's not relevant.
Not.
How's it not relevant? Not even your
That's my
oath of office?
determination, sir.
Nope.
So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in
How is
front
it
of the jury.
relevant to your?
Why is it
your-
not relevant? Can you?
Mr. Brooks,
Can you
You
explain
are
why
not
that's
going
not
to
relevant?
be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office.
subject
I didn't say
matter
anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice.
And we all know when he says that, in his smooth brain with absolutely no ridges or any kind of intellect, he has really making me ashamed of myself. He honestly believes that their duty would be to set aside and just ignore the laws of, unaliving people and let him go home. Unbelievably, the level of narcissism, it just exceeds understanding.
That if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to
So they can't even know that I got a shock device on my ankles.
What does
They
that have to do?
absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
I will argue that it
your
is.
conduct from November 21st of 2021 is what
That
is
hasn't
on
been
trial.
proven.
Well,
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay.
It's my constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which I
you're-
preserved my First Amendment right when I came in this morning, I also preserved my
All right,
Sixth
Mr. Brooks,
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered? I
It means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr.
Yeah,
Brooks,
like with
I'm
the
putting you
snake.
on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because
Regardless.
they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct your
land.
attention
The
to
law of the
closing
land.
instruction 460,
I'm
which will
going.
be
I'm
read
going
the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States.
use United States.
You can't. No state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Yep, yeah, you repugnant thing. Okay. The 10th Amendment, and I would have to pull it up and read it, but my understanding is the 10th Amendment gives each state the right to govern itself and make its own laws. Isn't that what it does? That is why there's a federal law for marijuana, but the states have started to make their own laws that are different around it. There you go.
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why
My
I'm
low
addressing this
understanding.
before they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved, the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
And void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument.
Oh my God.
In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation, and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty. All of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California. Or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record?
Never.
As I've tried to do numerous times by saying
Never.
I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. I am not
allowed to
required
make the
to give
record
you
at
that
all, Your Honor?
opportunity, sir.
Nope.
I'm not allowed
Sir,
to make the record at all? As I just let you did, because some of the
Sir,
issues
I
has
have.
been some
You
of the
have
issues
told me
has
what
been
you want to do. I've
Your
told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and is unlawful law. You haven't shown
Unlawful law.
one time that is lawful for you to do what you've been doing as
Mr.
far
Brooks,
as your rulings.
Once again, I'm not going to debate with you the prior rulings of this court. There is absolutely no need at this point for you to make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an
I'm
opportunity, if
going to
convicted,
inform the
raise
jury.
every issue.
Contempt.
What? How
Hold
did
me
that
contempt.
skip?
I have constitutional rights that are being trampled on.
No, you don't.
And you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to
civilized
be
than a
respectful of the court's rulings,
Your
whether
Honor,
he
I
agrees with them
I
or
haven't
not.
dishonored the court.
Yes, you have.
I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the way
not
that you have through
disrupting
the
the
course
proceedings.
of
You just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not even
the
in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that the jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you
present.
to be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my satisfaction.
record
It's
has
about
been
the
made.
Constitution. It's about what's right.
Are you going
Never.
to
Are you
follow
going to
the
answer
court's
questions as a public
framework?
servant on why you're making up laws that are not in the Illinois versus Allen? It never
You
utilized the
are-
mute button. It
go
never
back
said
to the
anything
jury.
about a
Thank
mute
you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a
he
mute button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not,
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom
Thank you.
next
As a
door, and I
public
will
servant-
There
invite
you
you
go.
back over when it's
That's
time
what's
for
going
your
on.
closing.
You can't-
Okay, so what I see is that he doesn't understand the fact that she is able to be more civilized with applying the rules of those cases. In other words, one of the things says that you can gag. What is the difference between mute and gag? If she had acted in a more savage, primal way, he may have understood what was going on. He is so he's like he's like trying to perform this task that they're doing with an animal in the room, like just jumping around, like oh my gosh.
Invite me back over, I can reclaim my right. So how can you invite me
All
to do
right, the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I can
and
do
you'll
so
mute me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my First Amendment right.
I wish she would have gagged him. I wish she would have gagged him. I'm trying to charge my. Oh, he's already in there. Oh, and hot. Standing there like an animal. Like the animal that he is. I need to get some water.
And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be
hear
given
this again.
sufficient discretion to meet the circumstances of each case.
My parents were awesome when I was growing up. My dad's still alive. My mom passed away a few years ago. They were awesome parents. They weren't perfect parents. They were awesome parents. But I'll tell you something my dad used to do. There were three of us, three girls. I don't know how my dad survived that. We were horrifying. I mean, we weren't that bad, but we were. I mean, not in a millennial kind of way, but in the 1970s, 80s kind of way. So, he used to, like, if somebody did something wrong, my older sister was usually the culprit when we were really young. He would sit us, all three of us, down. Now, Kara was a little bit, she got a little bit of a reprieve every once in a while, but we were all punished for what one person did. That's what I feel like this is. We're all being punished for her having to repeat all this case law for what Daryl's done.
No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So the The cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle. And she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
He like is yelling.
Please
Kind
could
of
you
hear
confirm that
it.
the audio and video are working in the next courtroom? And the clerk's shaking her head, they've done that, thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test.
Yes, could we please?
Please. Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable?
They can see it.
All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off the PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good, thank you.
All right, with that, the jury is to be brought out.
All right. I'm going to pause here and take a bit of a break because I'm pretty sure it was gross watching me eat. I totally love everybody's support. I am shocked. I do this as a hobby just to get my mind straight, sometimes just to have an outlet for myself to be able to talk. I guess I didn't realize how much I really did like getting my opinion out, even though I'm not sure it matters to anybody. But so just thank you all for joining. Thank you all for supporting. Thank you for all of your comments, positive and negative. And like, subscribe, and let's keep pushing on. Maybe we'll get through at least the closings and the verdicts and the victim statements. So there we go. That's what we got here. That's what we got left. All right, it's Patty Jo. Let's do this. And I will see you later.